Can a court stop you from selling your property? Imagine you're trying to sell your house and you get a legal notice from the court that can stall your sale. So in this video, I will explain using a recent Ontario court case how these things can be done. So before I discuss that case, there's a couple legal concepts I want to talk about. First is what we call CPL, Certificate of Pending Litigation. To do that, you require court action. You need a formal permission from a judge and an order to register against a property. So CPL, they act as a public warning flag for showing people that there is a legal dispute over who owns and has the right to the land and the property. Whereas we have another tool called liens. Often we heard that somebody has registered a lien against the property. Lien can be easily registered simply by going to land registry office. You don't need court involvement. It is a legal hold or a financial charge placed on the property to guarantee a debt is paid. For example, if somebody hired a contractor and they did not pay him for his work, contractor can put a lien on your house. And also you can have a mechanic's lien, you can have owing taxes. So CRA can also put a lien on your house, but that is a different tool. For purpose of this video, I'm going to purely focus on an Ontario court case and talk about CPL, which is called Certificate of Pending Litigation. So when you registered CPL on your title, it just shows there's a litigation affecting your property. So if you're looking to buy and sell property, your lender, your bank, and your lawyer will do a title search and they can find these registered court authorization notices registered against your property. And they can definitely hamper the sale and refinance of your house. Now coming to why people do that. So I have seen in my real estate business, often when we are selling properties, we do title search through lawyer. We find these things. Often CPLs are used for ownership disputes, land boundary fights, spousal and family claims. And in this case, which I'm going to discuss, so what happened is a plaintiff sued a builder for $525,000. The reason was problematic home construction, significant issues with construction deficiencies, overcharging and breach of contract and misrepresentation by the builder. So the plaintiff sued the defendant and went to the court and asked for approximately $525,000 in the lawsuit. So while the lawsuit was going on, a property bought by the defendant, approximately 239 acres for $1.95 million, was transferred for just $2 to his parents. And that is basically last year, January 29th, 2025, and he bought this piece of land in 2022 and transferred into his company. Then just weeks later, the property was listed for $2.4 million under his parents' name. So the plaintiff argued in the court that this was an attempt to put the property beyond the reach of the law. So why did the court grant him CPL? The court looked at three major factors. Court looked at number one, there was a high probability that the plaintiff would recover something in underlying lawsuit. So court was very sure that the claim against the builder was legit, and he's asking $525,000 in damages. So court think the case is pretty solid, and they just want to make sure because they have enough evidence in front of them to see the transfer of the property by the builder to his parents' name was intended to defeat or delay the creditors. And without the CPL or certificate of pending litigation against the property could potentially be sold and money moved out of the reach of the plaintiff. So therefore the court ordered and allowed CPL to be issued to the plaintiff. And here is the update. In 2026, the defendant asked the court to discharge the CPL from the title. The court refused. The CPL remained in place. So here is the big takeaway or the final takeaway. Remember, a property is not necessarily safe from the lawsuits just because the owner transferred the title to the family members. A suspiciously timed or a nominal transfer can trigger or attract serious court scrutiny. In this case, he bought the property for $1.95 million and transferred to the parents for $2 while the litigation was going on. There was a serious red flag. Third, CPL can have a major consequences for the sellers, buyers, and the lenders. So if a CPL or a lien against registered against your property, you can't refinance your house, you can't sell the house because during the title search, these issues will come in forefront. So follow me on my channel, my social media, if you are looking for Ontario court cases judgment, tips and pointers for sellers, buyers, landlords, and the tenants. My name is Jimmy Singh. I'm broker of record, Fortune 2 Realty, serving real estate needs for clients across Southwestern Ontario, Greater Toronto area. Thanks for watching.